How's it going, everybody? Welcome back to Lead Therapy, and I really appreciate you taking your time tuning into my video. After watching the video, if you appreciate the information that I gave you, please take time to like, share, and subscribe and hit those post notifications. I really would appreciate it. A federal judge has ruled that assault weapons are protected by the Second Amendment. A federal judge in Illinois has declined to put a stop to the state of Illinois' new ban on so-called assault weapons, along with a similar prohibition locally imposed by the city of Naperville, ruling the firearms in question aren't protected by the Second Amendment in the first place. U.S. District Judge Virginia Keller's ruling in Beavis versus the city of Naperville isn't binding precedent, thankfully, and I'm not sure the Seventh Circuit Court of Appeals is going to be willing to play along with her assertion that semi-automatic firearms, arbitrarily designated as assault weapons, are dangerous and unusual, given the fact that the arms in question are the most popular type of rifle sold today. In her ruling, Kendall wrote that the Illinois and Naperville bans meet the burden because assault weapons are particularly dangerous weapons, and high-capacity magazines are particularly dangerous weapon accessories. Their regulation accords with the history and tradition. Once you hear the rest of the judge's opinion, you will definitely see she's a biased judge. Naperville and Illinois lawfully exercised their authority to control the possession, transfer, sale, and manufacture by enacting a ban on commercial sales, the judge wrote. The weapons banned by the Illinois law are unquestionably in common use. The lawyers for the NRA argued an arm that is in common use for lawful purposes is by definition not unusual. Such an arm therefore cannot be both dangerous and unusual, and therefore cannot be subjected to the blanket ban. Kendall ruled that the government can regulate highly dangerous arms, including assault weapons and large capacity magazines, that impose an unusual risk that can cause greater harm and more deaths. The text of the Second Amendment is limited to only certain arms, and history and tradition demonstrate that particularly dangerous weapons are unprotected, the judge wrote, and assault weapons are not commonly used for self-defense, and gun owners have many other firearms they could use for protection. Judge Kendall's ruling is replete with questionable arguments in favor of upholding the ban on semi-automatic firearms designated as assault weapons, including her assertion that a few short-lived regulations from the 1900s are proof that semi-automatic rifles, or perhaps all semi-automatic firearms, aren't covered under the Second Amendment protections. Notably, semi-automatic weapons themselves, which assault weapons fall under, were directly controlled in the early 20th century. Rhode Island prohibited the manufacture, sale, purchase, and possession of any weapon that shoots more than 12 shots semi-automatically without reloading. Michigan regulated guns that could fire more than 16 times without reloading. In total, 9 states passed semi-automatic weapons regulations. 23 states imposed more limitation on ammunition magazine capacity, restricting the number of rounds from anywhere between 1 and 18. Regulations in less than half the states is hardly evidence that these types of laws were widespread or long-lasting. There were 8 states that had may-issue carry laws on the books when the Supreme Court struck them down in the Bruin decision. So Keller pointing to regulations in 9 states, few of which actually prohibited the sale and possession of semi-automatic firearms, doesn't have quite the heft the judge was hoping for. Still, Keller's weak argument still has the weight of law. Thankfully, Beavis versus Naperville isn't the only challenge to Illinois' gun ban underway, and Keller isn't the only federal judge that's considering the unconstitutionality of the assault weapons prohibitions. Let's hope that the others actually look at the text of the Second Amendment, along with the history and tradition, when making their ruling, instead of looking for any excuse they can find to keep the gun and magazine ban in place. Like I said early on in the video, this is definitely a biased judge. The Second Amendment is plain and simple, and what part does shall not be infringed the judge not understand? I would really like to hear your guys' thoughts in the comment section. Do you agree with me that the judge is biased? And as always, I appreciate you guys' support with the channel by liking, sharing, and subscribing and hitting those post notifications. And I really hope to see you guys in the next video.